Thank you everyone for coming. We're going to hear arguments in the case Washburn versus Hernandez. It's a state action / free speech case. The court's going there. You're going to hear the petitioners argue 2 points. They have to, first I'll give you some background. State University of New Hampshire baseball players started to protest an injustice that happened within the city. And when the baseball players started to protest during the national anthem, it led to some violent reactions in the audiences, in the crowd. So the school decided they needed to step in because they were losing millions of dollars. It wasn't a handful of people, they were losing millions of dollars. And as a result, the chancellor and the board of trustees got together and said, we need to adjust the student-athlete handbook to restrict student-athletes' freedom of speech in just that narrow way, that they could not engage in any political speech that involved putting any words on their jerseys, they couldn't have any physical gestures, they couldn't say anything outwardly before, during, after competition, whether on campus or at any other school's venue. The student athletes that came in 2018 understood this rule, they signed their student athlete handbook, and a volleyball student, Raquel Washburn, was pulled over, or she was stopped by police and she was harassed. And as a result, she decided she was going to start protesting. And before her volleyball game, she engaged in political activity, or political protest, and a riot broke out in the stands. People left and demanded a refund, and the school awarded the refund. She got called into the chancellor's office with her counselor and with the dean of students and was warned, you cannot do this. This is a complete violation of the student athlete handbook that you signed. You understand this. She acknowledged that she understood it, and she went on to do it again the next game, which led to another violent riot and put dozens of people in the hospital. And as a result, Chancellor Hernandez decided to dismiss Washburn from school. She lost her scholarship. She was on athletic scholarship. She lost her scholarship, and she was dismissed from the school. So what you're going to hear the petitioners argue is that, one, Chancellor Hernandez was acting in her capacity as an official of the state, and two, that the student-athlete handbook restriction against political speech is a violation of speech. So those are the two questions that the court is going to have to answer. The Chief Justice and the Associate Justices of the United States. Oh yay, oh yay, oh yay. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention. So the court is now sitting. God save the United States and this honorable court.
We will hear arguments this morning in case number 12826, Washburn versus Hernandez. That's it.
Madam Chief Justice, and may it please the court. The act of stripping Raquel Washburn of her athletic scholarship in response to her political protest is a violation of her First Amendment right to free speech. The 2 points I will be making before the court today are that Chancellor Hernandez is a state actor and that the contract that student athletes attending NMSU were required to sign is a violation of their First Amendment right to free speech. Firstly, I would like to speak to the role of Chancellor Melody Hernandez as a state actor. Chancellor Hernandez's role as a state actor determines the relevance of the argument regarding whether the policy preventing civil disobedience is a violation of the First Amendment. All activities of a state actor must adhere to a state constitution. I would like to take a moment to reflect on the precedent case of the NCAA, National Collegiate Athletic Association, versus Tarkanian in 1988. In the case of the NCAA versus Jerry Tarkanian, the NCAA produced a contract for sports teams nationally, which were signed by parties partaking in national level collegiate competition. However, it was the decision of the Nevada Supreme Court that given that the NCAA is a private organization that serves on a national level, the NCAA is decidedly not a state actor. The NCAA was determined not to be a state actor given that the source of the rules adopted by the NCAA is not the state, Nevada, but collected membership, a vast majority of which located in other states. The NCAA is not bound by any state institution. There is no public access to determine how the NCAA operates. The Board of Governors is completely internal. However, in the case of NMSU, as a state university, it is accredited by a state government board. State universities are organized and operated pursuant to provisions of state constitutions, regulations, and statutes. To conclude the discussion on the subject of Tarkanian versus the NCAA, I would like to clarify that in the case of Raquel Washburn versus Chancellor Melody Hernandez, it is a NMSU specific university policy that's violation results in a change in relationship between the student and the university. The contract was created by the state of NMSU for the student athletes of that specific university. Therefore, under the definition of a state actor that the NCAA did not fit, NMSU does fit. In addition, I'd like to present the court with a brief note about the relevance of the ruling of American Future Systems versus Pennsylvania State University, in which the Third Circuit Court of Appeals ordered that Pennsylvania State University was a state actor. The court declared the university to be a state actor for the purpose of determining a case relating to the First Amendment, as it is the same with our case today. Although there is a variation in the facts of the First Amendment cases, the decision that the state university was a state actor in the role of making decisions regarding the definition of the state constitution remains. Both Pennsylvania State University and North Mountain State University are state actors. Now, I would like to clarify that we stand here today not to directly question the position of the university as a state actor, but the defendant, Chancellor Melody Hernandez. Melody Hernandez is an employee of a state-funded university. As stated in NCAA versus Tarkanian, in performing their official state functions, the executives of the state university unquestionably act under the color of state law. Therefore, for all the situations in which Melody Hernandez acts in her role as chancellor for the university, she is an individual acting on representation of a state university in New Hampshire. And given the previous evidence that the university by which she is employed is a state actor, Melody Hernandez herself is undoubtedly a state actor. The importance of Chancellor Hernandez being a state actor is so that as long as she is a state actor, she's acting as an element of the government, not a private institution. If she was acting as a party of a private institution, it would be approved for the institution to limit.
We would like to let you know that we concur with you on this matter, so if you'd like to.
Yes, I'm wrapping.
Move on.
Yes.
You're welcome.
All right. Now we would like to move on to the policy in the student handbook and explain why it is a violation of Ms. Washburn's First Amendment right to free speech. To do this, I would like to turn the court's attention to the NMSU policy that all athletes are required to sign and explain how it is unconstitutional. The following is a statement as part of the policy in the student handbook. I understand political statements may come in the form of verbal statements, physical gestures, holding signs, or adding additional text to jersey or other equipment that is visible to the public. The petitioners would like to state that we are aware that Raquel Washburn has violated this policy. Her kneeling and raising a balled fist was a symbolic gesture, but we do believe that this policy itself is unconstitutional, provided that we have declared that Chancellor Hernandez is a state actor. Now, I would like to take a moment to step away from Raquel Washburn for a moment and look at the policy itself. The First Amendment guarantees citizens a right to free speech. While this right is not unabridged, this policy limits the rights of students in an unconstitutional way. Yes, perhaps there are things that students could have done to violate this policy that are also not protected forms of free speech. But that does not change the unconstitutional nature of this policy itself, which clearly prohibits students from multiple forms of speech, including spoken words and symbolic actions.
Does it necessarily prohibit them from making those forms of speech, or just from making them specifically before or after athletic events? Can the policy in this handbook not be seen as a constitutional restriction on time, place, and manner of free speech?
We believe that, yes, this policy is very specific to the athletes of NMSU. It is declared in the handbook, it is signed by student athletes, and it is at the time of the game. However, it does not change the relevance of, it doesn't seem like there should be a certain place in which the students we believe that the particular statement.
First Amendment jurisprudence says that the government can, in fact, regulate speech so long as, or it can regulate the time, place, and manner of speech so long as it first does so independent of the content of the speech, which it seems like it is doing here, given that it is prohibiting any form of political speech, not just the symbolic speech taken by quit here, and it also mostly opened ample other channels for expression, which they do not seem to be limiting the student from exhibiting her political views at other points on campus or at other times aside from athletic events. What would you say?
Although my co-petitioner will be speaking on this later, I would like to speak to the Brandenburg case, and I would like to speak to the fact that this is indeed a case in which, let me gather my thoughts. So in Brandenburg, we have a very specific imminent lawless action standard, correct? And we believe that this is a very, recent case. It comes in 1969. And we believe that there was no intent of the petitioner, Raquel Hernandez, to incite this lawless action, and therefore we believe that it is inappropriate for the policy at the time of the game to restrict her actions. So although we are aware that there is a time and place significance, we believe that given that her intent was not to incite lawless action, that should not be relevant.
Well, that may have protected her at her first match where she took this political stance. After viewing the audience's violent reaction to this, it would seem that she knew it was going to incite a violent response. Therefore, is she truly protected under the Brandenburg standard?
Well, we believe that although her first action may have incited violence, we also believe that it is not fair for it to be her duty to we do not believe that it is that she can expect the same crowd to react the same way every single time. We believe that yes, that's what I'll say to that.
So are you arguing that, from what I understand, you agree that it could be a constitutional restriction on time, place, and manner, but you think that the imminent lawless action standard, the fact that you're saying this did not constitute an imminent threat, that her intention wasn't there, and you're saying that should overrule the fact that it could be constitutional in terms of restricting the place and time for speech?
I'm just going to phrase this. So I believe that we believe that the policy is unconstitutional. We believe that the policy is unconstitutional because it is restricting her right to free speech and her ability to speak, to provide. We believe that she should, regardless of the time, place, and manner, that she should be able to advocate for her political beliefs. And we believe that her specific actions did not follow any of the precedent cases that would incite any sort of imminent violence or threat. So no, we do not believe that in this particular case that should hold significance. The time, place, and manner should hold significance because we believe that that overall the policy is a restriction of free speech.
But the policy isn't prohibiting her from a certain type of speech or a certain political statement or the content of her speech that she might be making. It's only saying that she's not able to make that speech before or after athletic events.
Yes,
right?
and we believe that is a limit of free speech. The fact that they are
So you just believe that the government shouldn't be able to restrict the time, place, and manner of free speech?
Not in this case. Not because of the type of action in which she performs.
So even after there was a violent reaction to her speech, so that was the fact that people would react in a hostile manner. And in Frere, we saw that there is some degree of responsibility for the speaker. His arrest was valid, and the reaction, he was, held responsible for that. So should we not hold her responsible for not only repeatedly acting after the violent reaction?
So we're specifically arguing the nature of the policy that she signed and her
Sure.
violation of that. So that's like the specifics that we are focusing on is the policy itself. And because she was expelled given the nature of her violation of the policy. So that is the nature of the case. It is not a matter of, that would be a government case regarding like arrest is I think what you're speaking to. We're speaking to specifically her expulsion and her stripping of her athletic scholarship because of the violation of the policy.
But wasn't the policy enacted in the first place because of the university's concern about the reaction of audience members to protests such as these, as you stated earlier? Is it the still unconstitutional if they enacted the policy in response to a prior incident that's a precedent for this one?
Yes, because we believe that the policy was an unconstitutional reaction to the behavior. You know, perhaps we believe that the policy that they enacted, the wording and the restrictions on symbolic speech are unconstitutional in that case.
I don't know if we can necessarily, within this case,
I think
separate it.
we're at time,
Right.
right? Yeah. So
Thank you.
thank you,
Justices
Ms. Dick.
and Madam Chief Justice.
Mr. Edelman?
Madam Chief Justice, may it please the court. My name is David Edelman for the respondents. Students at public schools do not shed their First Amendment rights on campus. This is a long-standing principle of constitutional law and one that we are not here to dispute today. Nevertheless, as Justice Fortas wrote in Tinker v. Des Moines Independent Community School District, the First Amendment right to the freedom of speech must be applied in light of the special characteristics of the school environment. Today, the court considers whether North Mountain State University's student-athlete handbook policy is constitutional. To find the answer, we believe that the court should determine the university's use of the policy in light of the Tinker standard for limiting student speech. We do not believe that the Brandenburg standard of imminent lawless action applies in this case. So to assess the university's compliance with the Tinker standard, that's a two-part question. First, of course, does the Tinker standard apply to public universities? We believe that it does.
Can you begin, Mr. Edelman, by explaining why you think that the Brandenburg standard doesn't apply here?
Certainly. So the Brandenburg standard applies to the government as a whole, and it presents the most restrictions on the government's ability to suppress speech because, just in general, we try to place as few limitations on the First Amendment as possible. However, the court has in previous decisions recognized the uniqueness of the educational environment and recognized, as they did in Tinker and in other school speech cases, that the school environment demands an allowance to administrators to restrict speech in ways that create an environment that is positive for learning. And so we've seen in cases like Tinker that they give the government and administrators at schools more leeway to restrict student speech in pursuit of that goal. So we believe that Tinker, which gives the government a little more leeway in terms of how they want to restrict student speech, is the proper standard to apply in this situation because this is a school speech
But
situation.
Tinker was applied for a high school, not for a university.
And for I think even as young as
Elementary
students
school.
impact. And in subsequent cases such as Bethel School District, Hazelwood School District, we saw that the court recognized that these rulings that were held in secondary schools and elementary schools did not necessarily apply to either adults or even students in colleges or universities. Students on this university campus are generally going to be adults. Can we still apply the same standards in Tinker in this case?
Yes, and you stated rightly that the court explicitly declined to extend the Hazelwood standard to colleges,
Yes.
but they did in fact extend the Tinker standard to colleges in the 1972 decision Healy v. James, where the majority opinion explicitly referenced the Tinker standard, writing that, and this was a case about whether a chapter of Students for a Democratic Society could form on a public university in Connecticut. The court wrote that in the context of the special characteristics of the school environment, the power of the government to prohibit lawless action is not limited to acts of a criminal nature, and that would be the Brandenburg standard, as you stated. Also prohibitable are actions which materially and substantially disrupt the work and discipline of the school, quoting from Tinker and applying the Tinker standard in that case. And the Supreme Court has applied the Tinker standard to universities. Lower courts have also done so. The Minnesota Supreme Court did that in a recent decision. The Third Circuit of Appeals did that in a recent decision. So there is precedent, a lot of precedent, for applying the Tinker standard at the college level. And I understand your hesitation to apply more restrictive standards like Hazelwood or Bethel School District, but the Tinker standard is still fairly, it's a high bar for the university to pass. And so I understand you would be reluctant to extend Hazelwood or any of those to the college level, but I think in light of precedent and in light of the amount of speech that is still guaranteed under the Tinker Standard, I think the Tinker Standard is the proper one to assess the university's policy.
Do you think it's still fair to consider this under this Tinker Standard, given that we're talking about a scenario in which the protest was taken at an athletic event that was open to the public, where adults were mainly present, where it was not necessarily during school hours, though it might have been on campus? This is a public university, so we're on public government-owned property. And there are no restrictions necessarily on who can come to this event. It is open to the broader public. So is it still fair to assume that the same standard that needs to be applied in schools to be applied to an open athletic event at the university level, where most of the rioters in response to her protest were not even necessarily college students?
Right. Well, I don't think the facts permit us to say whether the rioters were students or outside fans, but I think this is still an athletic event run by the college, subject to what we would consider general college discipline rules in terms of drinking, rowdiness, that sort of thing. And it's at a university where the participants are going to be athletic students. So I think that this would be generally considered an event put on by the university and subject to the Tinker Standard as an event occurring within the university. Because really the point of the Tinker Standard is that it allows public schools to ensure that speech does not materially and substantially disrupt the work and discipline of the school. And certainly I would say that extends to athletic events. If they are disrupted, that disrupts the functioning of the university as a whole. So I'll address the factual basis for assessing the university's handbook under the Tinker Standard. I know that the court is already familiar with the facts in this case, but I'd like to revisit them briefly just to provide a foundation for that. So the first violence occurred at North Mountain State University in the spring of 2017 after the baseball team elected to raise their fists during the national anthem as part of a political protest, and that resulted in fans throwing glass at the players and walking out of the stadium. And after that, the university enacted a policy that banned political statements, public political statements, by student athletes immediately before and after athletic events. And Chancellor Hernandez made this decision along with other university administrators with the interests and the safety of university students and university visitors in mind. Now, student athletes at NMSU are required to familiarize themselves with the handbook, and the facts of this case indicate that the petitioner did so as well, that she was familiar with the handbook and knew the rules in it. However, in the fall of 2018, petitioner opted to violate the handbook rule against public political statements at athletic events by taking a knee and raising a fist in protest of the Exeter Police Department. And this was the same action that the baseball team had taken last year, and unsurprisingly, it led to the same violence in the stands. Fans threw bottles, engaged in fights, and 15 fans were arrested for their role in the riot. So we saw a continued pattern of political protest leading to violence in the athletic events.
In the facts of this case, it clearly states that due to disapproval from trustees of recent displays of civil disobedience, NMSU's athletic department, at the urging of Chancellor Melody Hernandez, amended the student athlete handbook. Do you not think that that kind of goes against your argument that it was in order to prevent this violence because it was due to their disapproval of the civil disobedience as opposed to preventative in terms of violence?
And similarly, it is noted that the university lost over $3 million from expected ticket sales. Do you think that might not have played a role in their student athletes policy as well?
Certainly, yes. I think there were multiple factors that went into this, but the key factor, I believe, in the mind of Chancellor Hernandez was her interest in the safety of all students, because I think it's fair to say that rioting in student athletic events at the college level is very uncommon, and so it's highly undesirable, and there's a real desire on the part of the administrators to avoid any further acts of violence. And since we clearly saw that what caused the violence was the political statements made by the student athletes, the administrators wanted to prevent any possible violence from that from happening in the future, which led to the handbook policy.
So it's certainly true that as an educational institution, the university does have an interest in maintaining the civility and on its campus pursuant to its educational mission. But doesn't the university also have a responsibility to encourage the free exchange of ideas among students? They must balance their desire to maintain order on their campus with their desire to encourage their students to share their ideas. And so I'm struggling to see how since they did not necessarily have precedent to know for sure that her protest would invoke violent action, is it necessarily fair to restrict her free speech? At what cost is that coming at in this case? Shouldn't the free speech of students still be protected on college campuses? That's essential to the very nature of a higher educational institution.
Well, certainly, yes, and I think that we should try to give students outlets to express their political opinions whenever possible, so long as that does not, according to the Tinker Standard, materially and substantially disrupt the functioning of the school. And there are many other avenues for petitioner to express her political views. This policy does not restrict student athletes from making political statements at other times, in the classroom, on the quad, in their dorm rooms, putting up posters elsewhere on campus. It merely restricts them from making political statements immediately before or after an athletic event, because really, that is not the time to be making political statements when it's been demonstrated in the record that these statements have a strong history of creating violence in the stands. And so I think that the restriction in this case is reasonable because the risk of disruption from the political statements at this very limited time and place is too great.
Couldn't you argue that restricting her from speaking at games would disallow her from reaching a larger audience and would restrict the people that she can reach to only the student body, because there are outsiders that do not currently attend the school who are coming to these games who would not be receiving the same messages because they're not walking around campuses and looking at all of the posters, say, in the dormitories and so on and so forth?
Yes, I think your point is well made, but there are numerous avenues for her to express her political opinions in a way that does not disrupt the functioning of the school. And I think that it's important to keep those in consideration, that she can put things in, she can write to the newspaper, she can write things online, she can do all manner of things, as long as her political actions are not going to materially and substantially disrupt the functioning of the school. And I think that this sort of restriction, it's a temporary one, really, in the sense that we have a particularly heated situation that we've seen in this case. Past instances of student athletes making political statements have led to violence. If circumstances were to change and it became less likely that any statements made would lead to violence, then I think this policy would no longer be necessary.
Madam Chief Justice, and may it please the court, first I would like to reflect on what my co-counsel talked about, being and that you agree with, that Chancellor Melody Hernandez is a state actor. And I would like to also reflect on her point about this contract being a limit on the First Amendment rights to free speech guaranteed to the students of this university. And I will get back to that, but before that, I would like to just return to Raquel Washburn's actions specifically in this case. So Raquel Washburn chose to kneel and raise a fist, which is a form of symbolic speech that is conveying an idea or message through behavior. And in this case, Raquel Washburn was trying to convey the message that she thought the Exeter Police Department was lacking in accountability. Now, symbolic speech is still speech, and speech is protected by the First Amendment. And there are some instances where speech is not protected. Now, the policy in the student handbook is in question under Shank and Finer. And we're going to briefly talk about these two cases just because they are mentioned. However, we believe that there's a more applicable standard for this case, which I will get to after briefly covering Shank and Finer. So in Shank, the ruling in Shank was made in 1919, and the court's opinion said that the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. So this opinion effectively set up the clear and present danger standard, the standard that would rule in free speech cases for the next 50 years. And during the course of these 50 years, another case was decided, Finer, the other case that this policy is in question under. And because of that clear and present danger standard that was set in Shank, the court ruled that Finer's arrest was not unconstitutional. Now, the standard set in Brandenburg v. Ohio in 1969 supersedes that of Shank set in 1919, and therefore we believe that that standard set in Brandenburg in 1969, that standard being imminent lawless action, should be the standard applied in this case. So, the standard of imminent lawless action essentially clarified what constitutes a clear and present danger and limited that to be something that can be evaluated in two parts. So the first part is that speech can be prohibited if it, 1, is directed at inciting or producing imminent lawless action, and 2, if it's likely to incite or produce such action. And Ms. Washburn's speech simply does not meet both of these criteria. So I would now like to explain how Ms. Washburn's actions do not meet the Brandenburg standard of imminent lawless action. Let's examine the first requirement of the Brandenburg standard, that the speech must be directed at inciting or producing imminent lawless action. Raquel Washburn taking a knee is not directed at inciting or producing imminent lawless action. Washburn decided to take a knee and raise a balled fist during the national anthem to protest the lack of police accountability in the Exeter Police Department. That was the speech that Ms. Washburn's action was trying to convey, that the Exeter Police Department lacks accountability. Now, I ask you, what lawless action is this trying to promote? And I hope that you'll come to the same conclusion as me. It isn't trying to promote any lawless action. She's simply trying to say the Exeter Police Department is lacking in accountability.
What about the fact that, as we mentioned earlier, after her first protest, she witnessed the consequences of her actions and the violent reaction from the crowd, and yet she returned again to repeat the protest? Can we really fairly say that she had no intention of inciting the same response again, or at least no awareness that the same response might occur?
I think that, first of all, it's unfair to anticipate what the reaction of a different crowd on a different day and different circumstances is going to be, and I think that placing all of that burden on Raquel Washburn is slightly unfair. I also believe that more importantly, the actual message of what she's trying to convey through her speech should be what is judged, not some external reaction to that speech. And that actual message is that the police department is lacking in accountability. That actual message isn't throw bottles, it isn't like hit the fans next to you. The actual message that she's trying to convey is just that the police department lacks accountability. So she wasn't even really asking her audience to react to this message in any way. She was just simply making a symbolic statement to protest something that she felt strongly about.
Can't we look to Finer in that instance and say the same thing, where he was not attempting to incite violence, and yet threats were levied against him, and the response of the police was to arrest him, and it was ruled that his arrest was lawful because he was causing disruption and causing a clear and present danger. So the intent of his actions wasn't actually to incite this violence, but he still incited it, and he was aware that he was inciting it, which it appears that she is here as well, and it was ruled that he was allowed to be arrested. So why should we not regard Finer in the same manner here?
I think that in Finer, the intent was clear in the fact that his speech was verbal, and he specifically said
things encouraging people in his audience to rise up in arms and fight for their rights, which is a bit more explicit. I understand your point here that the symbolic speech is less explicit in the message of trying to incite violence, but the fact that it is symbolic speech does mean that we must think back to the Tinker precedent here, which says that symbolic speech in schools is permitted, but only to the point that it is not disruptive to the operation of the school. So, although you're applying the Brandenburg standard here, can you speak to the fact that we are in a different environment here, in a school environment, as opposed to in some other sort of public forum?
Yes, so first I'll answer Justice Karp's question about the finer standard. And I think that, as I mentioned earlier, finer was decided before the Brandenburg standard was set, and so they were still using the clear and present danger standard in order to evaluate finer speech in that case. And I think that perhaps the result would have been different if they had been using incitement to imminent lawless action standard rather than the clear and present danger standard that they were using. So I think that the Brandenburg standard changes that from being extremely relevant to this case here today. And now to answer your question about Tinker, I would like to go back to some of the comments that were made when Mr. Edelman was speaking about how Tinker was really a case that was decided for an elementary school, and how it's difficult to apply everything that's relevant in an elementary school to a public university, especially during a sports game. And so, while perhaps parts of the Tinker standards should apply, and of course we should take into account the overall ruling of the Tinker standard, it seems like every small aspect isn't necessarily applicable to this public university in this completely different setting, which is a sports game that's open to the public, not just elementary school kids in their classrooms.
So are you arguing that the sports game is not part of the operation of the school, and therefore it does not materially and substantively interfere with the operation of the school, since it's a sports game? Like, are those two separate entities?
Well, clearly the sports game does materially and substantively affect the operations of the school. It's a major source of revenue for the school. But I don't think that applying all the same standards, such as like interrupting the educational environment of an elementary school, I don't think that that is necessarily as applicable in this case, when it's not the specific classroom environment of elementary school kids, and it's rather like a more general, open to the public sporting event at a public university.
But didn't they lose a lot of money in this case? So that would affect the school environment to lose that much money?
Yes, it does affect the school environment to lose that much money.
So how does that not make that apply?
How does that not make what apply?
How does that not? Yeah, the Tinker standard would protect the school in limiting this action as it materially and substantially interferes with the school's educational role in the lives of its students.
I'm arguing that, so yes, the action that Raquel Washburn took did materially and substantially affect the school's environment, and that would mean that it's applicable under the Tinker standard, but I don't think that like the entire Tinker standard should be applied to this case, given that it's a completely different situation.
But as Mr. Edelman stated, we have seen this case applied to many university cases.
And I think that that's perhaps premature. I don't think that that's necessarily relevant in this case. So I would like to move back to the Brandenburg standard, which is applicable in this case, and look at the second requirement, that the speech must be likely to incite or produce such action. However, before we do so, let me remind you that unless you think that Washburn's speech was directed at inciting or producing imminent lawless action, this part of the standard is simply irrelevant, because there needs to be some sort of such action that the speech, which is the Exeter Police Department lacks in accountability, that Washburn is trying to convey to her audience in order for this part to even be applicable. So if Ms. Washburn was not intending to promote violent action in the first place, how can it be judged whether people were likely to follow her instructions? That simply doesn't make sense.
I think the problem with that is saying what likely is, and in my opinion personally, after the 15 people committed a riot, even if you were arguing that it could be like just that day, or like it could be a different group of people that wouldn't have a riot, but I would argue that one instance of violence and such an isolated, like 2 instances of her protest, like an instance of violence on the second time would be enough to argue that it was likely that other people would incite violence based on
She
what
continued her protesting too. She didn't stop after people were
distinction here between the message of Raquel Washburn's symbolic speech and the reaction to that message of the audience. So there's a difference between what Raquel Washburn is trying to convey to the audience and how the audience is reacting to that message. So in this case, Raquel Washburn isn't trying to tell her audience to react in a violent way. This is a non-violent protest, and she's just kneeling and raising a balled fist to protest the lack of accountability in the Exeter Police Department. And the reaction of the audience, well, it's completely independent. Well, it's not independent from, it's obviously because of that symbolic action, but it's not in reaction to what Raquel Washburn is telling them to do in any way. It doesn't align with the message of the speech.
But we have in the facts somebody saying who was violently arrested because of their race said she had no right to disrespect my dad's service in this country, so it was clearly affecting like herself.
Clearly.
And she would clearly, like, the reason that they were raging was because of her action.
Yes, but again, I think that there's a distinction between how an audience member is interpreting Raquel Washburn's speech and what Raquel Washburn's speech actually is. And I think that any audience member could interpret speech to be something completely different from what it is, and that interpretation, placing that responsibility on the person making the speech to anticipate every possible reaction.
But doesn't
that an
so many
audience-
people reacting in the same way?
And could you not argue that making ambiguous speech that could be interpreted in multiple different ways could also be part of the issue here, and that if she just chosen to say that she felt that there was a lack of accountability in the police department, that this would be a different scenario? Because that person's response, where he said that she was disrespecting his dad's service to the country, could you not argue that that lack of clarity in what she's trying to say by doing that is part of the issue here, and that her decision to use this certain symbolic speech is part of the issue as well?
Perhaps Raquel Washburn could have chosen a clearer way to convey her message to the audience, but it's simply unfair for her. For the standard for free speech, you have to think of like the best possible way to convey your message in order for the speech to be protected. Like, yes, Raquel Washburn's message was somewhat ambiguous, but she was still kneeling and raising her fist to protest the lack of police accountability in the Exeter Police Department. And I think that this speech is clearly symbolic speech, and asking her to in some way like maximize the efficiency of how her message is going to reach her audience is just an unfair standard for free speech. Thank you.
Okay. Madam Chief Justice, and may it please the court, as my co-counsel said in his introduction, students do not shed their First Amendment rights to freedom of speech at the schoolhouse gates. This has never been a question in this case. However, when a certain form of speech has been known for causing a disturbance and leading to violence in a school environment, there are actions that must be taken in order to maintain the peace of the school environment.
If we're talking about maintaining the peace, though, it sounds more like we would need to apply the Brandenburg standard. What your colleague seems to be suggesting is that this was infringing upon the school's ability to fulfill its educational mission. So in this case, if we're talking about the violence of the crowd at an athletic event, is it really fair to say that that is impairing the school's ability to fulfill its mission of educating its students in the classroom?
Well, sorry, could you say that question one more time?
Yeah, so you mentioned that the violent reactions of the crowd were disrupting the peace of the school, which sounds like it's calling for an application of the Brandenburg standard, which your colleague said should not be applied here, that the Pinker standard instead should be applied here, which says that, which would say that the protester, that her speech could be regulated because he was arguing that it interfered with the educational mission of the school. And is that really fair to say that a protest at an athletic event can interfere with the school's ability to educate its students in the classroom?
Yes, I suppose I misspoke in saying that it interferes with the peace of the school, but rather the educational mission of the school. and its ability to function as a school. Or as, yes, something. Okay. Anyway, my co-counsel talked about the Tinker vs. Des Moines case, which concerns a group of students that were suspended for wearing black armbands to school as a way to publicly display their support for a truce in the Vietnam War. Here we consider the question of whether or not the school's prohibition of wearing armbands violates the student's right to free speech via the First Amendment. Now, the conclusion of this case decided that in order to justify the suppression of speech, the school officials must be able to prove that the conduct in question would materially and substantially interfere with the operation of the school. The Des Moines school officials feared that the armbands would cause a disturbance. However, fear alone is not an excuse for limiting the student's right to the freedom of speech. An actual disturbance is the only thing that could justify restricting the speech of students. This is precisely what we see in this case. After North Mountain State University's baseball team raised their balled fists during the national anthem to raise attention to the lack of accountability for the Exeter Police killing of local jazz musician Marvin Robinson, hundreds of crowd members angrily booed and threw glass bottles onto the field. In response to this incident, the university had planned to implement a new rule in the student-athlete handbook by fall 2018 that restricted student athletes from making any kind of public statement before or after an athletic competition. Regardless, Raquel Washburn decided to raise her fists and take a knee during the playing of the national anthem at NMSU's first home league match to protest a lack of police accountability within the Exeter Police Department. This led roughly 2,000 fans to violence, and at least 15 of the violent arrestees admitted after being taken into custody that their rage was sparked by Washburn's protest. After meeting with the school board reminded her of the rules and explained that there would be punishments for any further public political statements. Although Washburn disagreed with the policy, she acknowledged that she understood the university's position. However, even after a clear reminder of the rules and the potential threat her public political statements could present to the athletic environment, at the next home game, Washburn repeated her protest by again taking a knee and raising her fist during the playing of the national anthem. The consequences were much more severe this time around, resulting in the breakout of a riot and the hospitalization of 20 fans. The school then justly punished her for disrupting the school's educational environment and its work.
When she's using a form of peaceful protest, though, can she truly be held responsible for the reaction of these fans? Her message is a very peaceful message. She was simply kneeling and raising her fist. At what point?
Yes, but what I would argue is, as we've seen in the past, this kind of symbolic speech has had a negative impact on the fans and has led to some serious consequences. So, in knowing that, I would argue that this speech, she could have the knowledge that this speech would lead to a similar result as it did in the past.
But I'm gonna ask you, you're really utilizing Tinker, and don't you think there's a distinction between, students have to go to middle school and elementary school that's legally allowed. Exactly, versus a voluntary sporting event when people choose to do that. Which is also open to the public, aside from the college students there.
So, yes, this athletic event is open to the public. However, it does not change the fact that it's still run by NMSU, and it's an athletic event that revolves around their university.
That is true. The court has previously established, and as was cited in Hazelwood the case of Hazelwood School District, they're not established there. School facilities can be public forums if the policy or practice of the school has opened those facilities for indiscriminate use by the general public or for a segment of the general public. And I think that would qualify here, given that this athletic event is open to the general public. I think that I don't necessarily agree with your colleague that the Brandenburg standard does not apply at all here. So if you would speak to the issue of whether or not the protesters' actions intentionally provoked imminent lawless action, that would be appreciated.
So, I guess what I would say is that the symbolic speech itself, I don't think they intended to incite a violent response.
Well, if they didn't intend to incite a violent response, then it doesn't constitute imminent lawless action.
Then, well, I draw back to the Tinker case in that circumstance because in the case, the suppression of speech, as I said earlier, in order to suppress this kind of speech, the school officials must be able to prove that the conduct in question would materially and substantially interfere with operation of school. And having known this kind of action has happened in the past, I would definitely say that Washburn's symbolic speech most definitely interfered with the action of the school.
In Tinker, though, it also states that a minority opinion that deviates from the views of another person may start an argument or cause a disturbance. But our Constitution says we must take this risk.
But it's not, what I would argue is that it's not as much of a risk when you know that this kind of stuff has happened in the past, and that this kind of result is predictable based
So
on
you're
what we've
saying we
seen.
must silence minority opinions because they cause disturbances?
What I'm saying is that in a school environment, in a university environment, when there's been a pattern of this kind of stuff in the past, and that these kind of outbreaks have been a result of this certain kind of symbolic speech, that the school, in its right to protect its students and maintain the peace, or not the peace, but the working environment of the school has the right to limit this kind of symbolic speech.
But we're in an environment on a public university campus that is open to the public. At a point where students are adults here, is it really fair to say that the protesters' actions in this case interfered with the educational mission of the school, the ability of the school to educate its students in the classroom?
Well, I mean, you can tie, in general, you tie the athletics to the educational mission of the school. That's part of the school. And if a student was injured during one of these riots, they wouldn't be able to, and they were to be hospitalized, that affects their ability to go to school to learn their educational situation. So.
But what about the general public who aren't even affiliated with the school besides going to sporting events? How does the school have the ability to limit their expression and their free speech when they're not even affiliated with the educational part of the school?
Well, it's not. See, it's just not about limiting the speech of the public. It's limiting the speech of. It's just specific to the university because the student or Washburn's action has been not only Washburn. The symbolic speech that we've seen taken by the students of the university in the past has caused a negative impact or a negative outbreak or a riot, I guess, in the past, and that this ruling is in order to prevent such violent outbreaks in the future.
Right, but we must make a distinction between violent reactions to speech due to a speaker's direct advocacy of violence in the crowd, and violent reactions to a speech due to audience members' disagreement with the speaker, right? We can't silence people because people react violently because they disagree with them. We can't silence speakers because their opinions are controversial, right? So I guess I'm still looking for an answer to the question of, by the Brandenburg standard, do you believe that this intentionally provoked imminent lawless action?
Well, I mean, again, I just don't think the Brandenburg standard can be applied to this case nearly as much as the Tinker can, because one, Tinker concerns symbolic speech, but two, it also covers the environment of the school. So I don't think it's fair to use the Brandenburg case over the Tinker.
The environment in an elementary or high school.
And again, we're at a university level in a public area of the campus.
I mean, as David said, in Healy v. James, this Tinker was obviously used in the conclusion of the court as part of this case. So there's no question whether or not this can be applied to universities. So we've seen that it has in the past.
Would you not say that this, the amendment to the handbook and everything does not directly target the chancellor? Because if, like David said, there's a bunch of avenues for her to express, these political statements on campus, but she cannot do it on the field. So would that not be very targeted and muting of what she wants to say?
Well, I mean, I guess I don't really understand. Could you explain?
Yeah, so I am saying that don't you think that the school's editing the handbook directly after her first incident, don't you think that directly targets her and her ability to speak?
Well, the school's mission, what I would argue is that the school's mission is not to limit the speech of one single student because they think that there could be negative consequences, but rather to limit any kind of speech that could result in a disturbance in the school environment or a violent outbreak, or a result such as we saw in the final, before Washburn was suspended, or expelled, sorry. So I don't think it's specific. It can be incorrect that it's specific to this one person when the school's mission is to keep the work environment clean, I guess. Or
Thank
safe.
you. Thank you.